Hey everyone, Harry here to set up just where we are now. It turns out to be, after the response from DA Alvin Bragg, a very pivotal spot and one that's going to play out likely before the inauguration on the issue of what happens to Trump's convictions in the 34 convictions in the New York court and the prospective sentencing. So recall, trial judge Justice Juan Merchan agreed to hold off on a scheduled sentencing a couple times. First, he let it move past the election, which was a little bit against the grain of what he had been doing and others like Judge Chutkan had been doing in just ignoring the whole electoral context. And then with the DA's consent, he let Trump bring a big motion saying you should dismiss the whole thing. And as I laid out in a different YouTube, so just very briefly to summarize, Trump not only tried to leverage the immunity opinion to say that this conviction, which concerned almost exclusively pre-presidential conduct. This is the hush money payments to Stormy Daniels and the fraud involved in that overall scheme, that it was all before. Not only, said Trump, should it be dismissed for that reason, but he played two more really kind of dubious cards. One said, as a president-elect, I'm in the same position as a president. All the things about the dignity of the office and not impinging on the 24/7 responsibilities, which I guess include all the golf he plays, mean that you need to do this now, even though I'm a president-elect. And moreover, you need to do it for all time, not just suspend, but actually terminate and sort of vaporize from the pages of history the whole lawsuit. Okay, so Bragg comes in with a pretty measured and tempered response, which sets up where we are now. And in broad strokes, Bragg gives a lot of ground and says, yes, I understand that there are special considerations here now that the convicted 34 times over, not defendant, felon, has been elected president of the United States. And in particular, I bow to the principle, even though he could have fought it. It's not so clearly established in law, but I bow to the principle that anything involving these proceedings cannot occur while Trump is president. So as of January 20th, you couldn't sentence him. Just briefly, you could argue, he could have argued, a sentencing is really not very much. The court says you can go through with a whole civil case. Why is this a big deal? The counterpoint to that would be, well, all the sort of opprobrium, as the court said, in the immunity case, the sort of institutional injury to the president and the presidency and how it might hamstring a president. That would be the reason. Anyway, Bragg gives up on that and says, once you become president, we understand we can't do anything. But what that sets up is the question, can they nevertheless either sentence him or preserve the possibility of sentencing him down the line? And this is really where the battle is now joined. And given the way Merchan set it up, he could just rule on this anytime. He could have a hearing, but what he said is, you guys do this motion and then I'll figure out what I'm doing. And so he, could simply come out with a written order. But Bragg gave him a menu of 3 different options to at least keep alive the fact the important pronouncement of a jury and a justice system that we have in the president-elect of the United States, someone who's been convicted of 34 felonies, and it would be very detrimental for a number of reasons, but especially public confidence in the judicial system to just see that kind of wiped out. Obviously it's exceptional circumstances, but why should it be, with everything on the side of accountability, everything that goes into every criminal trial, for the public to see that a rich, powerful, yes, presidential candidate, now president-elect like Trump, just sort of makes it all go away, really is undermining of confidence in the judicial system, and surely it is. Okay, so Bragg says, here's what you can do, Judge. First of all, he says, this thing about president-elect, it's bullshit. We have, this isn't how he puts it, but it's how I would put it. We have, it's very clear, one president at a time, and that president is Joe Biden, and a president-elect is another name for a citizen, and until he's exercising the powers of the office, he is not entitled to any of these extra considerations that animate the immunity opinion, the OLC opinion, which is showing up here quite a bit and will figure, I think, in the litigation. That's the opinion, recall, where the OLC opined that you can't prosecute a sitting president, whether it's for immune, non-immune conduct, whenever. You just can't. It could be a 10-year-old, shooting someone on Fifth Avenue. You can't do it while someone is president, so it doesn't have to do with immune versus non-immune. Anyway, Bragg, acknowledging all these, says you can still do three things, Judge. First thing you can do, sentence him. Boom, just pronounce it. And at that point, his appellate rights kick in, and there'll come a time around January 20th where everything, all the appeals just have to freeze. That's the way it goes under the OLC opinion, the immunity opinion, etc. And at that point, you'll have a sentenced convict. So talk about, preserving it. That's where it stays 4 years thereafter, or whenever he leaves office. Bragg, continues to phrase it that way, which is sort of a puckish reference to the possibility of, a third impeachment if the House changes into Democrat hands and Trump continues to flout the Constitution. But anyway, just sentence him. So that would be the next thing that could happen. He could actually schedule a sentencing. At that point, either if he comes down with a sentence or if he schedules sentencing, Trump will go berserk and try to appeal, run out the clock until January 20th, when everything changes under the law. But there may be postures where Merchan says, please go ahead, but first I'm going to sentence you. That's where we are now. That's option one. And that's an option that, A, would make Trump apoplectic, and B, if you're giving much ground to all these principles, you would recognize that a president stepping into office with this sentence having been pronounced is a little bit more damaged goods, say, than one for whom it hasn't happened. Okay, says Bragg, but I'll give you another option where you don't have to go even that far. Don't sentence him. But come January 20th, everything freezes. The sentence doesn't go away. We're not going to just make the case go away. His claims for dismissal are bad, and you should so rule, Justice Merchan. And then it'll just be, in a sort of deep freeze, but not the same. In 2029, the freezer can be open, the sentence can be thawed. Now, so much can happen between now and then, but the real point here isn't even preserving that in 2029, but preserving it today. That is, having his status reflect that a jury, good and true, convicted him of 34 felonies. And then finally, a really exotic, odd, creative approach that, for that reason, I'm sure Trump will totally pillory. But it's an interesting idea. He says, look, There's some times where, this is Bragg giving a third option to Judge Mirchan. There's some times where a defendant is convicted, but before being sentenced, she or he dies. And there's a generally accepted practice, interestingly, not in New York, but in states around the country, many of whom employ what's called the Alabama rule. And here's how it works. You just, okay, the guy's dead, things are over, but we're not going to simply pretend this didn't happen. It could have collateral consequences, the criminal conviction of someone who since died, and B, that society has gone to all this trouble. It's passed judgment. It's set, it's guidance for accountability, and it's found this person should be accountable. We can't just wipe that from the books, even though, of course, Trump would really want it here. So what should we do? You make a notation in the record, Judge Mirchan says. He was found guilty, 34 counts. It then went up on appeal because he was elected president. Everything was thereafter frozen, and we didn't proceed to sentencing. And that's it. So in other words, what Bragg is saying is the appeal of this option, which is analogized to abatement cases, that's the kind of category where you use this Alabama rule, is to say it's done. I'm, basically closing up the file, and to the extent Trump is challenging the whole situation because of what it could do, or how it could hover over him as president, or could have future eventual consequences, they're all gone. It's all done, just as it would be with a dead defendant. However, that doesn't mean that the pages of history are just wiped clean. Rather, we note in the judicial record, the guy was convicted. We say, it didn't go all the way through appeal, so that, that's not to say the conviction became final, but the conviction happened. And that is where things stood when, because he was quite an entry, it's unprecedented entry in a judicial record, because he's elected president, everything stopped. That's the end of the matter. So that really is all the reasons Trump wants and cites for having this kind of off the books. That seems to satisfy, of course, what Trump really wants in so many ways, even including the 2020 election, is to rewrite history, a very characteristic ambition, by the way, of the authoritarian leader. My conversation with Professor Snyder at Yale and a lot of things in Orwell bring that home. But that's what the battle's going to be. So as soon as any day, you could find a sentence from Mirchan, or he may not sentence, but still order it to be in deep freeze. Trump will appeal those orders, but unless they're reversed, they stay. Or even this last ditch suggestion, fine, close up shop, but after making the official note in the record of just what happened here, which is critical. We can't pretend for the judicial system, all the more so given the prominence of the defendant, that just nothing happened. So that's the option, and it's going to be, I think, the battle's going to be joined on this. Not sure which way Mirchan will want to go. As I said, he's sort of blinked a couple times in recognition of the unusual situation that the case and he find themselves in. But that's going to be playing out, and pretty soon. So I'll be back as things develop there, but keep your eyes out for what Mirchan could be doing anytime as well. And until then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.